May I, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 17, Your Lordship. This matter to be listed after vacation. Supplementary hearing.
17 of the vacation.
Yes, Your Lordship.
Lordship, I'd like to mention item number 3.
Yes.
This matter fixed after vacation.
Yes. After vacation.
And Lordship, item number 16.
16
Same, Your Lordship.
after vacation.
And Your Lordship, item number 8. In this regard, I am filing wakalat nama.
8
8.
after vacation.
Yes, after vacation, I am filing wakalat nama.
Yes. Because, okay.
Your Lordship, I'd like to mention item number 15. As leading counsel is out of station.
After vacation.
No, after a week.
Huh?
After a week.
After a week.
Yes, Your
Okay. 15 after a week.
Honor.
My lord, item number 18, man.
After vacation.
Yes, ma'am.
Yes.
Lordship, may I mention item number 5 and 6, Lordship?
After vacation.
No, Lordship, 13 of this October.
Okay. 5 and 6, 13. Okay. 13 of October.
May I, Your Lordship, may I like to mention unlisted item, Your Lordship, that may be posted for tomorrow, Your Lordship.
Just a moment. Who is appearing? Who is the PP in item 5 and 6?
I am, Your Lordship. We have received the CD, Your Lordship, in this matter.
All right. 13, huh?
Yes.
All right.
Your Lordship, this is an unlisted matter, Your Lordship, that may be posted for tomorrow, Your Lordship. And this matter is with regards to criminal revision.
Have you filed?
No, Your Lordship, it is already filed, Your Lordship. This matter was in abeyance, Your Lordship, since last 2 months. With regards to that, Your Lordship, the other council, they have filed an applications to this Chief Justice with regards to transfer of matter from this court to Guwahati High Court, Your Lordship. But since there was a denial from the Chief Justice, Your Lordship, the matter may be fixed for tomorrow, Your Lordship.
What is the urgency?
That it has been in abeyance since last 2 months, Your Lordship. So maybe fixed for tomorrow for necessary order, Your Lordship.
All right.
Oblige, Your Lordship.
May I please, Your Lordship? Your Lordship, I beg to mention item number 4 for the adjournment.
After vacation.
Yes.
May I, Your Lordship? Your Lordship, I beg to mention item number 7.
After vacation.
Yes, Your Lordship. Much obliged.
My lord, I want to mention item 19 maybe. And listen.
After vacation.
Yes, my lord.
Huh?
Yes, my lord.
Yes. After vacation.
Highly obliged.
My lord, I have filed this criminal application under section 482 of Code of Criminal Procedure 1974, exercising the invoking the inherent power of this honorable court for compounding the non-compoundable offense between petitioner number 1 and petitioner number 2 for quashing of FIR, which has been registered as Narong PS case number 52/2007. So, my lord, this petition was earlier I have already filed, but there was some defection in FIR. So we have last occasion I was asked to annex the FIR with a typing. So this is a second time I'm coming before this court for this case.
Yes.
So my lord, here in this party has already settled this matter. So they don't want to pursue the matter.
What was the matter?
This is actually section 406, 465, 486, 471, 34 IPC. So, my lord, here during a time of the framing charge, we made argument because here FIR was this the section was wrongly inserted. Actually, the section 406 should be there. Breach of breach of trust. So accused was this complainant has handed over his motorcycle to his friend. His friend asking him to give his motorcycle. So I have some urgent matter. So in that matter, the motorbike was handed over to friend. So after few days, what happened? The motorcycle was not returned back. Not returned back. So this present complainant, he has lost a fire against the accused person. So later on, the accused the complaint come to know that his motorcycle was sold to another person. So after that, the conclusion, the motorcycle was returned back to the complainant. After getting the complaint from the accused.
Just a moment. We have not been able to make out who is the complainant,
Complainant
who
is
is the accused.
yes.
Petitioner number 1 is the accused. Petitioner number 2
The
is,
petitioner number 1 is the accused.
2 is the complainant.
2 is the complainant.
And FIR was filed in the year 2007.
2007, yes. So
When was it charge sheeted?
the charge sheet already charge sheeted and already
When?
it is in
Which year?
after 6 months it was charge sheeted. But this states, my lord, the PW states we have done the PW, the prosecuting witness we have done the 1-2. The SI also we have crossed the IO of the case. And I also revealed that the border party has asked me to withdraw the case. But meantime, the case was already registered. So he stated before the Honorable Court of the JMFC.
Health Minister? Who is to know this?
Yes, Your Lordship.
Health Minister?
T. Dukum.
T. Dukam.
Yes,
Dukam Rigya.
yes.
T. Dukam Rigya, Learned Counsel for the petitioners. And Miss T. Zini, Learned APP for the state. You should notice the returnable in 4 weeks.
Your Lordship also scan.
Call for the scan copy of the LCR. List it up to 4 weeks.
Thank you.
Your Lordship.
Yes.
Lordship, by this application, I'm seeking for a direction from this honorable court to be issued to the learned executive magistrate to consider and dispose of my application which is pending before him under section 133 CRPC. 133 CRPC. I have filed an application before the executive magistrate at Hayuliang, which was filed, but then that has not been registered and it has not been acted upon yet. So my simple prayer is that a direction may kindly be issued from this honorable court directing the magistrate to consider it as per the provisions of law. That is, prayer is very specific, brief. Your Lordship, page number 50 and Annex 4. Page number 50 Annex 4 of my application.
50.
5050.
Is there no alternative remedy?
Lordship,
Is there no alternative remedy on the inaction of the executive magistrate to exercise jurisdiction under 133?
Your Lordship, a remedy is always available to the petitioner or to any person when there is a sort of public nuisance being created by any agency or any person. So 133 can be invoked by the magistrate. So that is the reason why 133 CRPC has been invoked. And that has not been acted upon. That has not been registered on there. So my simple prayer is that may be disposed of and as per the provisions of law.
If I
Nothing
may,
else.
Lordship.
Huh?
If I may, Your Lordship. Lordship, in this, under section 133, Your Lordship, the specific power has been given to the executive magistrate, and he'll evaluate any complaint does not mean that it has to be registered, it has to be entertained. The magistrate prior to that has to evaluate if there is a case, Your Lordship. Now, this petition was filed on 11th of September, Your Lordship.
September.
Yes, Your Lordship. If it has been registered or not, because it has been received, Your Lordship. After evaluating the evidences, Your Lordship, then a so-cause notice has to be issued and the conditional order has to be made, Your Lordship. We are not well aware of if the same has been taken into consideration. Also, Your Lordship, if such a complaint is being
If
filed.
the magistrate does not act upon the
Yes, sir.
application under 133,
Yes, Your Lordship.
what remedy does the applicant has?
Applicant can also file a PIL, Your Lordship, if that is a public.
PIL?
Yes, Your Lordship.
No, no.
Because for him, it's the stone crusher, the nuisance. The license has been given illegally.
All right, you take instruction
Yes, Your Lordship.
when?
After vacation.
All
That's
right.
all right.
Okay.
On 14th of November, Your Lordship.
Will not issue notice at this stage? Let her take instruction.
It's all right. Notice is not required at this stage.
Mr. C.W. Monson, when it comes for the petition. And Miss. He is Vinny. Learned council, Learned APP. For the state representing R1. To press for listing of this matter on
14th of November, Your Lordship.
14th of November to enable her to receive instruction in the matter. Prayer is allowed, list it on 14th.
Obliged. Lordship, by this application, Lordship, we have, my prayer is that the chief judicial magistrate at Tezu had issued a non-bailable warrant of arrest against me for the reason that I have failed to comply with the interim maintenance order that is under 125 CRPC, which was filed under 125 CRPC. Now, I'm only on the non-bailable warrant of arrest having been issued by the learned CJM at Teju. Now, Your Lordship, here, page number 25. Your Lordship, Annexure 1, page number 25 is the first order. At the relevant point of time, it was CGM Rowing who was having the jurisdiction over
25.
page number 25, Annexure 1.
Yes.
At the relevant time, it was CGM at Rowing who was having jurisdiction over Teju. Now it's Teju. That was passed on 29/2017. This is the interim maintenance order. Now, Your Lordship may come to page number 26, the operating part of the order. That is an interim order.
Yes.
Page number 26. Second last paragraph. 1 and 2. I'm reading out 1. The respondent husband, father, shall remit the monthly interim maintenance allowance at the rate of 50% per month to the personal saving banks account number so and so of the applicant 5, mother operated in SBI Teju branch, Lohit district, AP, from the month of September 2017 onwards, pending disposal of the maintenance application. Number 2, the DDO / commanding officer, Assam Regiment of the Indian Army, Unit 957, pin so and so, care of so and so, shall deduct at the rate of 50% of the monthly salary of the respondent husband, father's recananso minin, from the month of September 2017 onwards as monthly interim maintenance allowance and remit the same into the account number of the applicant wife, mother, Srimati Jujumai Tawang minin, furnished herein above without fail till further order. The DDO commanding officer, Assam Regiment of the Indian Army, Unit so and so, is also directed to send the monthly payslip of the above respondent husband, father to this court on or before 2/11/2017 without fail. Now, this is the first interim maintenance order. Still at this stage, this interim maintenance order subsists. Now, subsequently, they have an allegation saying that I have been failing to comply with the interim maintenance order. So, in order to enforce that order, the respondent wife had filed an application under section 128 before the CJM at range. Page number 32.
Yes.
Page number 32 is the petition which has been filed by them. Which has been registered as criminal IA number 13/2018. When we come to the cost title, the first, it says maintenance case number so and so, that is reference to the case. Now, second number is the operating part, which is an interlocutory application under section 128 of the CRPC for enforcement of order of interim maintenance passed by the learned Chief Judicial Magistrate drawing on 20 September 2017 in the Fawcett case. Now, this is an application which has been filed by the petitioner wife saying that I have failed to comply with the interim maintenance order. In pursuant to this, your lordship may kindly mark it is 128 of the CRPC. Now, in pursuant to that, there has been issuance of non-bailable warrant of arrest. No notice was issued, in fact. Now, the last part is page number 73. Your lordship may kindly come to page number 73, Annex 12.
Yes.
12. Now, this is in the court of, now the case has been transferred. It has been remitted to the court of CJM at Teju, since CJM at Teju has established now. The address to the SP, Anjav district, Arunachal Pradesh, warrant of arrest under 78. Whereas respondent number so and so, under section 125 for enforcement of interim maintenance, you are hereby directed to arrest the Sepoy Kananso Minin and produce him before me on 13 October 2023 at 10 hours. 10 hours. Now, next date of the case, it has been fixed on 13th of October 2023. And this was passed on 10 September 2023. Now, your lordship may directly come to section 125, 128.
10 September?
10th of September 2023 is the date. 20th September, sorry, your lordship, it's 20th September 2023.
Okay.
This is the last
Yes.
order.
That maintenance case is still pending.
That is still pending, Your Honor. I have not been issued with any notice in order.
This interim maintenance was passed in your presence.
Not in my presence, in my absence. In my absence, everything in my absence. Page number 69. Your Honor. Their prayer is for 50% of the interim maintenance. Not interim maintenance, Your Lordship, for
This 29/2017 order was passed on the first day.
on the day of filing itself.
Okay, no notice was issued to you.
No notice was issued. And
Then, what is this subsequent order is page 28? (23/5/2018).
28, just a minute. Yes, this is in continuation to the earlier order. Subsequently, the respondent will appear and say that in compliance to the order which was passed, that was an ad interim order, ex parte order.
When did you appear? Then
We appeared subsequently.
when this order was passed, did you appear?
No,
23/5/2018.
23/5 we were there. No, we were not there. We're not there.
Okay. Then what is this order? 23/5/2018. This is for your personal appearance
Yes, and personal appearance.
on 19/7/2018.
Yes.
Then what happened on 19/7/2018?
We, on that day, we have submitted an application and informed the court that in terms of the first interim maintenance order passed by the learner CJ Metroing, we have
Okay.
duly intimated to our disbursing authority, saying that this is the order which has been passed by the authority, requiring your authority to deduct the 50% of the interim maintenance. So accordingly, you do it. That has been informed, because there was a specific direction given to the authority.
No. What was the info on that day?
We informed the respondent. The respondent husband had informed to the authority, his authority, his
Okay.
appointing authority, saying that the court has passed an interim maintenance order requiring this authority to deduct the 50% of my monthly salary. So accordingly, kindly deduct the same.
Okay.
So that was intimated to the authority, and it was accordingly thereafter
So-
intimated to the court
So
as well.
that means you were agreeable to this interim maintenance order?
We have never put to challenge of this interim maintenance order.
Not only you have put to the challenge, but you had instructed your disbursing authority
Definitely.
to deduct 50% of your monthly salary and give it to your wife.
Yes,
All right.
there was a specific direction.
Okay.
There was a specific direction requiring the authority to deduct and then accordingly remit it to the account of the petitioner. As
You
per-
you yourself had also instructed.
We have,
Okay.
we did,
Then
we did. And thereafter, now all of a sudden, now an application on the 120, since I have taken your lordship to.
Page
the
page
ma-
32,
Yes, maintenance,
128.
yeah, 128 application.
Okay.
Now, here they have come up for enforcement of the order which was passed on 29/2017. That was the interim order. They failed to comply with it. Therefore, this application is being filed for the purpose of enforcing of that interim maintenance order. Now, on the basis of that, this is the first application for enforcement. On the basis of this interim maintenance execution application, in fact, enforcement application, several orders were passed. Now, the ultimate order is that I should be arrested and put behind the bar.
So in between, what happened to the money? You have 50% salary.
50% salary that has been already given to the authority, Your Honor.
Which authority?
Authority, my appointing authority.
Appointing authority?
Appointing authority has been furnished with a copy of the order along with my application saying that this order is required to be complied with.
Okay.
Yes.
Have they complied with?
They have sought instruction, Your Honor.
They have not yet complied with. You are still receiving your 100% salary. Is not it?
That may be, Your Honor, that may not have been deducted, Your Honor.
See, account holder is you. Bond of contention is neither 128 nor 125. It is the 50% of
Your
your
Honor, it
salary.
would be very tough to explain at this stage because so many deductions are being made. My
What kind of deduction?
loan deduction is there.
That is immaterial.
Yes. So many deductions are being made. Now the question is, Your Lordship, what is the provision and the remedy available to the person in his favor?
If you want to stay of the warrant,
Yes,
you deposit your 50% of your salary from 29/2017 before the court, so that your wife can withdraw. And what would be the amount? This is the bottom
Your
condition.
Lordship, I'm absolutely on the point of, how can a court issue me a warrant when that court does not have a power at all, Your Honor? That power is not there.
Say, mister,
Yes, Your Lordship.
he sees your wife.
Yes.
How many children you have?
I should have been given the opportunity to place my defense. Sir.
Mister.
Yes.
How many
One
children you
one
have?
children.
One children.
Yes.
Now, see, though you were not given an opportunity when this 29/2017 order was passed,
Yes.
but this order came to your knowledge on 19/7/2018. Is not it? Then you not only challenged this order, but you yourself had instructed your disbursing authority to deduct your 50% of your salary and give it to your wife and child. But the authorities did not comply with. So the result is what your wife and children did not receive your 50% of the monthly salary till then. That is why this warrant has come. Well, see, crux of the issue is what? This is the 50% of your salary, which you yourself is ready to part with, not for anybody else, but for your wife and children. So you deposit it. Will stay the.
We are very much, it is not the case that we are failing to comply with the court's order. Here the issue is, since this is the code, wherein
Why should
I have been.
Why should we not ensure compliance of 29/2017 order?
That is needless to say. We are ready to comply with the order.
So then you deposit.
Now, my question is, my issue before this court is that whether a judicial magistrate first class or a chief judicial magistrate is authorized under law to issue me warrant. That is the issue.
That's
No.
why, see, that's why we will stay. But what about the compliance of the order of the magistrate?
We'll do it, needless to say that, because
Okay, when will you do it? You will have to do it before the next date, 13th of October. Next date is fixed on 13th of October. We will stay this warrant. You deposit it on 13th of October before the court.
we'll do it. Your Lordship may kindly come to one of the judgment. We will pay it, but then this is the procedure which is wrong, which is being adopted by the courts across the state. Whenever a maintenance order is being, there is an allegation of non-compliance of maintenance order, they directly issue arrest warrant, which is impermissible in law.
That's why we will stay.
That is what.
That's
Now,
that's why we will stay. But whatever the second part, this is second part, whatever the first part. Maintenance.
that is needless to say, we are ready to comply. We are ready to comply.
When will you
But
comply?
then how this magistrate could have issued with this warrant here? That is impermissible in law. That is impermissible in law.
Was non-payment of maintenance amount directed by the magistrate for the past 6 years?
Yes.
Was permissible in law? That is the first thing you will have to answer before you challenge this warrant. You may be right, but you equally will have to answer that.
Your Lordship, one thing, Your Lordship. Whenever a wrong order is passed by court, we cannot allow that order to sustain in the IFLAW, because we are very much ready to comply with the order. Now, whenever a court receives an application for its execution, Your Lordship, the
Okay.
court is required to issue me a notice at the first instance.
All right. Yes.
Your Lordship, I may be given the opportunity to submit, because this practice is being happening in the state of Arunachal Pradesh. Numbers of cases comes up, Your Lordship.
No, why? See, whatever this order,
We'll comply with that. We'll comply with
29/17,
that. Because I should be given the opportunity to object it before the court.
when
No
will you
notice has been
comply?
issued to me.
When will you comply with this order? It's been 6 years. 18, 19, 20, 21, 22, 23.
So many things are in between you. So many things came.
That we don't know.
Because
Who does it, huh? Yes,
Lordship may kindly come to just,
we will say it is illegal. Yes, warrant is illegal. Yes,
page number, Your Lordship may kindly come to page number 2.
page number 2,
Page number 2. Lordship.
there
This
are
is
6.
para 6, Your Lordship.
Yes,
Coming first, second, third, fourth, fifth paragraph from the top.
all right.
Your Lordship, after an order is passed, directing to pay maintenance, the party in whose favor such an order has been passed has got two options to work out to recover the arrears of the other. He can choose to approach the court under section 125(3) CRPC, requesting the court to punish the defaulter by imposing appropriate imprisonment. On the other hand, he can also approach the court under section 128 of the CRPC, seeking to recover the amount due under the maintenance order. A comparison of section 125(3) and 128 of the CRPC would keep things beyond any pale of doubt that insofar as the proceedings under 125(3) is concerned, the statute has prescribed a period of limitation of 1 year, whereas in respect of a proceeding under section 128 CRPC, there is no limitation provided at all. This is because while exercising the power under section 125(3) CRPC, the action being essentially a criminal in nature, resulting in punishment of imprisonment, the legislature has perhaps thought it fit to provide such a period of limitation of 1 year to file a petition. Since while enforcing an order under section 120 CRPC for recovery of amount, there is no question of straight away imposing such a punishment of imprisonment. That may be the reason for the legislature not to provide for such a period of limitation. Therefore, to put it in a nutshell, for initiating a proceedings for enforcing an order of invoking section 120 of the CRPC, absolutely, I find no provision providing for limitation as it is a petition, as it is provided in respect of proceedings under 125 of CRPC. In the case on hand, the petition was filed under 120 CRPC. Though it was filed beyond 1 year, in my considered opinion, the lower court was right in entertaining the same, as the same is not bad by any limitation. Here, the question of limitation was there, and there has been a distinction between 125(3) and section 128 CRPC has been explained. Your Worship. Under 128, under no stretch of imagination, warrant can be issued. Warrant is mentioned under 125. That too, warrant for the purpose of levying fine. Your Worship. Warrant for the magistrate has all the option to do that. 125(3).
This warrant has been issued pursuant to application filed by the.
Pursuant to the application file, Your Lordship, I have brought Your Lordship to page number 30.
32.
32, Your Lordship.
Okay, all right.
32. Now,
Now,
when there is an allegation.
now, just a moment.
Yes.
What will be the reference of this case?
What I'm trying to say by this
No,
judgment.
no,
Yes.
no. What will be the reference of this case?
Lordship,
This is neither AIR nor SCC. What will be the reference of this case?
it's on the top.
Madras High Court? Huh?
It's on the top.
It's
On the top.
on the top.
Yes, this has been passed in Madras High Court.
Okay.
This has been
AIR.
AIR 2010 AIR Madras
2010.
0 IR Madras 1717. The first citation. Even we have a case from Guwahati High Court.
But this is not AIR.
Yeah, this is AIR from Madras High Court.
This Vikas Info Solution has its own independent citation.
AIR Madras.
See, AIR Madras, there are a lot many others. Huh? 2011 one RCR Criminal 220. What is this? We don't know. This is original author is the Vikas Info.
Yes.
Huh? Solution. If you want to refer to AIR, you have to bring this AIR 2010. Anyway, we will say it is Vikas Info Solution Private Limited.
Yes.
Yes,
This has been, again, there is one judgment from our own Guwahati High Court
yes.
regarding. This was passed way back in the 1990, very old case.
This is again which citation? Supreme today.
Yes, Guwahati Law Journal is there, 1990, volume 2, Guwahati Law Journal 263.
Okay. Yes, which paragraph?
Your Lordship, first page, third para, last paragraph.
Paragraph number?
Para 3.
There are three.
Para 3. First page,
First page.
last para.
Yes.
The learned Chief Judicial Magistrate, thereafter, in order dated 14/8/89, took the view on the authority of division bench decision of this court in Idris Ali versus Rameshan Khatun, AIR 1989, Guwahati 24. That the petitioner was liable to pay maintenance even after the act had come into force because the order of maintenance had been made earlier to the enforcement of the act. On 1/9/89, the learned Chief Judicial Magistrate further ordered issue of non-bailable warrant of arrest against the petitioner for detention in civil prison until he paid the maintenance. Now, aggrieved, next page. Aggrieved with both the aforesaid orders dated 14/8/89 and 1/9/89, the petitioner has come in revision, and Sri A.B. Chaudhary, learned counsel appearing in this behalf, has submitted that learned Chief Judicial Magistrate by order dated 14/9/99 could not reopen the matter of maintenance, the same having been considered and decided by the learned Chief Judicial Magistrate by order dated 13/9/87, which has not been set aside by the learned Sessenger, but who had remanded for consideration other matters. Sri A.B. Chaudhary, learned counsel for the petitioner, has also submitted that the order dated one for arrest of the petitioner was also erroneous and liable to be and should be set aside. Now, I have heard counsel for the opposite party. The document is very short. I'm just reading on. Insofar as the submission of A.B. Chaudhary, learned counsel for the petitioner is concerned, while it does not appear that the learned Sessengers in his order dated 23/4/88 had not said anything to set aside the order dated 39/87 passed by the learned CGM, yet the matter had been remanded, maybe for some other matter, and the view taken by the CGM by order dated 14/8/89 on the authority of the decision of this court was sound and correct, and accordingly, I am not inclined in exercise of the revisional jurisdiction to interfere with the order dated 14/8/89. This is relevant now. Insofar as the order dated 1/9/89 is concerned, the order for payment of maintenance was to be enforced because the petitioner had not paid the maintenance allowance. Chapter 9 of the CRPC, hereinafter referred to as the code, in its section 128 provides for enforcement of order of maintenance. But how was the order to be enforced has not been provided. Now, section 128, the language has been reproduced. Para 10, the last paragraph. It only provides for furnishing of copy of the order. It also provides that such order could be enforced by any magistrate at any place where the person against whom it was made may be, which only means that the magistrate of the place where the person may be may enforce the order of being satisfied about the identity of the parties, and also that the dues had not been paid. As said before, how was the due to be recovered? That is, the procedure was not provided. Under chapter 32 of section 431 of the code provides any money other than a fine payable by virtue of any order made under this code, and the method of recovery of which is not otherwise expressly provided for shall be recoverable as it were a fine. The proviso of section 431 is not relevant here. The order of payment of maintenance was an order under the code for payment of money, for the recovery of which no method had been expressly provided. Accordingly, section 431 of the code, I think the maintenance money could be recovered as if it were a fine. In section 421 of the code, now this is relevant, Your Lordship. Section 421 of the code provides for recovery of fine, and the procedure laid down for the purpose was by issue of warrant for attachment, not arrest of warrant. Warrant for attachment and sale of any movable property belonging to the offender. In this case, the present petition opposite party in the maintenance proceeding or issue of a warrant of the collector of the district, authorizing him to realize the amount as arrears of land revenue from the movable or immovable or both the defaulter. The proviso to section 431 clearly stipulates that no such warrant shall be executed by the arrest or detention in prison of the offender. So on consideration of the above position, there should not be doubt that for the recovery of money as maintenance, which has to be in accordance with the procedure for recovery of fine, no warrant of arrest or detention of the petitioner could have been ordered. Now, Your Lordship, 128 nowhere says about the authority and the power given to a magistrate for issuance of arrest warrant for the purpose of realizing the amount arrears which is standing here.
Yes.
Now, there is a provision under 125(3) for the purpose of execution. So we should understand the difference between execution and enforcement. Section 128 uses the expression enforcement, which can be done by any magistrate regardless of the territorial jurisdiction it may be. But then 125(3) basically pertains to the magistrate which had originally passed the order. The 125 subsection 3 speaks about the procedure for enforcement of a maintenance order. First of all, when there is an allegation of non-compliance of maintenance order, warrant can be issued. It doesn't say warrant of arrest. It says warrant can be issued. Warrant for the purpose of levying fine. And for that purpose, notice has to be issued. Warrant of levying fine, yes, which is provided under section 420, where the same procedure has to be followed. Now, thereafter, after exhausting the remedy under 421, that is 125(3), the next step can be invoked. That is by sending the person to the civil imprisonment. When the first remedy is exhausted and that has not been fruitful, the next step can be jumped into. But then that has not been. Now, this is not an application under 125(3). This is an application which is under 128 CRPC. This is for enforcement. And the learned magistrate could not have issued with that, because whenever an application is filed at any cost, first of all, a notice has to be issued. Sufficient reasons has to be shown as to why that has not been complied with, or why there is an allegation. So, since that is an application which has been filed under section 120 CRPC, the learned CGM at Teju could not have directly issued the warrant of arrest.
When did you enter appearance in the maintenance case?
There is no specific date, but then after interim maintenance order, sir. I could not recall the exact date, but then after passing of the interim maintenance order. After passing of the interim maintenance, because record is so voluminous.
You had earlier submitted that on 19/7.
Yes.
Yes. 19/7/2018, which was the next date fixed by order dated 23/5/2018. You had informed your DDO
Yes.
to deduct it, but those pleadings are not there in your this.
It's there.
Let us see. Oh, yes,
It's there.
page 7.
Page 7 years.
Just a moment. In 23/5, it appears you had appeared before the court, before a magistrate.
CGM drawing, I appeared
23/5.
23/5. I cannot exactly say the date, but then we appeared once after passing of the interim maintenance order.
So did you appear on 23/5/2018 or not? Because you had earlier submitted that you did not appear. That is why there is an order for
our presence, the presence of the respondent is not recorded. That means on 13/5 by order dated 13/5/2018 of the CGM range.
no 23/5.
23/5, sorry, Your Lordship. Correct. 23/5/2018, Your Lordship.
Did you?
The
did
presence
you-
of the respondent husband, as well as his counsel's presence has not been recorded. That means he was
Not been recorded.
not been recorded. That means he was not present.
He was not present.
Yes.
Then you see your pleading at page 7, Roman 4. That is why then you read. That upon having come to.
Yes, this is an abetment to the effect that after having come to learn about the interim maintenance, the higher authorities.
I'll read it for you.
Yes.
Upon having come to learn about the apposite maintenance case and the directions contained in the interim maintenance order 29/2017, the husband had duly intimated to his higher and competent authorities to deduct the maintenance allowance as per the court order.
Yes.
All right.
Yes.
This fact has been duly intimated to the learned CGM at Rowing by the respondent, which was duly recorded in the order dated 23/5/2018.
Yes. This fact.
According to your statement,
Yes.
you had intimated this fact of
Yes.
deduction of 50% of the
Yes.
salary, but did you to the CGM
Yes.
on 23/5/2018,
On
which was duly recorded.
Yes. Recorded on 23, but then it was intimated earlier even. This fact was recorded by order dated 23/5/18 only. This fact was intimated earlier, prior to 23/5/2018.
When?
Prior to 23/5/2018. And 23/5/2018 says that this was intimated earlier.
You had appeared, Mr. on 23/5/2018. You yourself had represented upon revisiting the record, it transferred that on 16/3/2018, under counsel for the respondent husband, father, Mr. C.W. Manda,
23/5
had informed this court. That, okay, copies of the.
earlier.
All right.
That was of earlier.
Okay, what is the status of your marriage now?
My allegation is absolutely false. Absolutely. The allegation is that I'm having an extramarital affair with some women.
You're not
That is
concerned.
not-
What is the status? Are you still the husband and wife?
We are still husband and wife. We have been calling. You come and stay with me. She's not willing to come and stay. Otherwise, I'm serving in the Indian Army, Indian Army, like Scout, Indian Scout. Otherwise, I'm also running very.
But you have not
hardships.
taken, you have not taken any steps either for getting a divorce or to challenge the interim maintenance. So there's no way out. It has to be complied with.
That would be complied with. That is there only. We have intimated. We have intimated and we will do it. Because here we have all the remedy and right to make our submissions before the learned CGM regarding all these facts. But then at this stage, since warrant of arrest has been issued and your lordship may kindly come to the last order by which the same order, the day on which this arrest warrant was issued finally, page number 69, your lordship may come to page number 69 of the order. This is general order. That is the warrant, this is the order. Page number 69. Annex 9.
Yes.
This has been passed on 29/2023. Last part here. Come to page number 17. Para 4. In view of above observations, the officer commanding Delta Company, Arunachal Scout PO Chaglagam PS Kupa Anjab district is directed to stop payment of monthly salary. Directed to stop payment of monthly salary to Sepoy Kananso Minin forthwith. OCPS Howling, who is personally present in the court, he is directed to serve a copy's order to the commanding officer Delta. So it's all. So my
Response, this petitioner was present in court also on that day.
petition, this present petitioner was not present. He was not present. He was not present because he did not.
What is the maximum maintenance permissible under section 125?
Amount is not there.
Not there, no?
And
It
the
can
amount
be.
was up to 500 that has been amended way back. Now it is up to the discretion, and for the purpose of filing maintenance, Supreme Court has laid down the guidelines saying that whenever a maintenance application is in file under 125, there has to be a complete affidavit in regard saying the respondent who is supposed to pay the maintenance. The petitioner has to show that he is having this much of income and this is the property, affidavit has to be filed. So all these things, we would say, so unless this affidavit is filed, no maintenance is permissible. Supreme Court is very clearly said that. So we have not been.
So we don't know how much maintenance is due in terms of this order. According to you, how much it would be?
It will be very huge amount, huge amount.
Huh? How much?
It
How
would
much?
be very huge an amount.
How much? Roughly, approximately.
We need to calculate it.
Huh?
We need to calculate it.
What is the 50% of your salary?
But I cannot say the exact amount of my salary, 50%, because our salary, it increases and it decreases very frequently. So,
We have to specify some amount. That's what I'm asking. Otherwise, 50% it will be very vague.
that is what.
You will not know how much to deposit.
That is what,
Yeah.
50%. We are not saying on the order of the magistrate, because 50% was the main prayer which has been claimed. And that main prayer which is claimed in the petition has been granted in the earlier interim, which is otherwise of the impermissible. That is another aspect. We are not an interim maintenance. We are on the arrest warrant which has been issued, and the proceedings. I'm challenging the proceedings of IAT number 13 of 2018. Because that application is absolutely erroneous. And the proceedings which is being initiated. That is impermissible in law. The word-
But you have to tell the approximate figure. What will be the amount?
That part. That could be directly said by the authorities only.
You know, you are getting how much?
Sometimes 30,000, sometimes 35, sometimes 40. It's not always the same amount I'm getting.
You are not a regular employee.
I am a regular employee, but not the same.
There is a
amount.
basic scale of pay. Then
40,000.
how can the salary vary?
There has to be a.
Salary will vary only when the increment increases or other allowances increases.
At any cost, your lordship, an opportunity of being heard should have been given to me. No opportunity, no notice has been issued to me. Nothing. Directly straight away with this notice. That too with fault in illegal process.
Lordship, here, Lordship, the order dated 29/23, Lordship, which is his challenging, Lordship. And nowhere it is mentioned that the warrant of arrest has been issued. Here, Lordship, this paragraph 1, Lordship, here it is written that the petitioner Srimati, this is present with his counsel, respondent has not appeared in connection with the 2018 and non-development was issued, Lordship. That time that non-development warrant was issued against the respondent number and the respondent is Lordship. Sri Kanasa Main. At that time, the superintendent of police Hawaii, Magistrate O.C. Halan was directed to execute the warrant of arrest against the accused. Personal appearance of O.C. Halan was also directed. At that time, Lordship. And also here, Lordship, and again in paragraph 2, Lordship, the O.C. Halan was personally appeared. He has submitted that the warrant of arrest could not be executed against this respondent as he is on leave. Leave certificate with home address has been furnished. He also informed that the Wakro police attempted to execute the warrant in the home address of the
Warrant is
respondent.
not under challenge.
Lordship, he was like warrant under challenge according to this order. But here this order, then no warrant was issued again, Lordship. This was reflected the earlier order, Lordship, which was passed on 2018, Lordship. And Lordship, in this order, Lordship, kindly Lordship, paragraph 3, in this order, after due consideration, it appears to me that this orders is like this, Lordship. It appears to me that the respondent this mean is deliberately and willfully neglecting the order dated 2/4/2018, which was passed earlier, Lordship. Passed by this court, whereby interim maintenance was granted to petitioner and the respondent was directed to pay a sum of rupees 15,000 as interim maintenance. The commanding officer, Assam Regiment, the first Honorable Riang Junai Assam was also given a copy of the order dated at that time order, Lordship, 2/8/2018 to 2/4/2018. On 8/2023, the officer, this lawsuit, this 18/8/2020, this year lawsuit, the officer commanding Delta Company, first under Scorpio Changlang Kompa under this was again directed to deduct a sum of rupees 15,000 from the monthly salary of the respondent person and submit the SY account of petitioner, the respondent, but it has not been completed till date. And lordship, in view of the above observation, the officer commanding Delta Company, this is directed to stop payment. This directed to stop, here this order lies lordship. It directed to stop payment of monthly salary to Sipai Kamansu forthwith. OCPS Palyang, who's personally present in the court, at that on 29/2023, the officer lordship, OC Halan, he is personally present. At that time also he was not present. The respondent was not present. In the court, he is directed to serve a copy of this order to officer that lordship to withdraw this amount lordship. To serve a copy of this order to the officer commanding Delta Company, Arunachal Scorpio Changlang Kompa and submit a copy of the served order with endorsement from the office of commanding Delta Company, first Arunachal Scorpio Changlang Kompa to this court on or before the next date fixed. Any failure to comply with the aforementioned direction either the officer commanding Scorpio Changlang cell or the OCPS Halyang cell entail criminal proceeding as well as contempt of court proceeding fixed on 13/10/2023 for report and necessary order. That's it, lordship. There's no non-violable arrest was issued, lordship. And lordship, let the respondent appear, lordship, on that day. Then necessary order will be passed. Whether it will be comply 421 CRPC or not, that will be decided on that day, lordship. He has to appear, lordship, because he is running away, lordship. Since lordship 6 years, lordship, he is not taking part in the proceeding. He every time he was absent. At that time, that warrant of arrest was issued. But lordship, till now, that warrant of arrest was not complied. No, he was arrested. No, he is appeared before the court.
And this warrant was issued pursuant to which order?
This
Lordship,
order,
Huh?
same, there is no any, if that be the case, there is no any order as such.
No, lordship, lordship, to this recent order, there was no warrant of arrest, lordship.
There's no mention, there's no reference to this order.
Yes, there is a latest arrest warrant, page number 73.
73.
Page number 73 is the latest.
It has been issued pursuant to which order?
Pursuant to this only.
But this order
They
does not
already
make a
did,
mention,
lordship, there's no.
does not make a mention of any warrant.
Yes, this is the main case. This is the main maintenance case. Page number 68. Page number 68. Page number 68 is the IA. That is the main maintenance case. We are on IA. We are on IA. We are not.
Here, lordship, we are directed to arrest, lordship, but this lordship, warrant arrest, it was not reflected in the order, lordship.
Page number 68. Madam, page number 68.
You are challenging page 69 order, 29/2023.
Yes.
Is not it?
We are challenging the arrest warrant as well as the order also. Order stopping my payment.
Now let me, lordship, then seek the instruction, lordship, because lordship.
Just a moment. Page 68 is another order.
Yes, this
Awesome, yeah.
this pertains to IA. This pertains to 128 application.
Okay.
This is Flushing.
You are from Wakro. Native of Wakro.
I am from Vakro, originally from Vakro circle, not Vakro, my Kamja village. My village is Kamja village. It comes under Vakro circle only.
Wakro is in Phonsa, Longding
No,
district.
it's Lohit.
Lloyd. Okay, Lloyd. Your wife is from?
She's from Teju. She's staying in Teju.
Teju. Native of Teju.
they're from same community.
Yeah.
They're from same community and their matter is in the process of their settlement also. The wife is, the
So
wife is very-
then why have you filed this petition?
because warrant of arrest has been issued, warrant of arrest and then this order, this is very vague order, stopping the payment. 125, 120 CRPC, can it be invoked and direct the authority to stop the payment? Absolutely no, yeah. This is absolutely an abuse of process of law.
13/10/2023. Then you appear on 13/10/2023.
Lordship, may I direct to Lordship to pass appropriate order, Lordship,
Ah,
on that
on
day,
that
Lordship.
day.
Yes, that order may be passed from here, Lordship.
You appear on that day.
Lordship.
All right, we'll appear. We'll appear. We'll appear.
And the appropriate court below may pass necessary order as per the provision of law.
Okay.
So that's it.
Absolutely, the order should be passed appropriately only as per the provisions of law.
You are appearing for anybody.
This morning I had an instruction on behalf of respondent number 2 to appear, but I could not receive the wakalatnama, so
Okay.
I was unable to present my case.
What does she has to say?
Respondent number 2 is the wife, Lordship.
Ah. So let him appear on that day,
And Lordship,
is not it?
Lordship, he has been evading the proceedings for the last many years, Lordship.
In fact, notice has not been served upon me. 120.
Regarding what?
Regarding 128. Yeah.
No, you have to contest the main case. That maintenance case, which you are contesting, I think.
Sufficient cost, 128 says sufficient cost. Notice has to be given to me and I should be given the opportunity to place my submissions.
Okay.
It says sufficient cost. Submission of natural justice. No, otherwise they're in the body.
See. You may be right when the law is read in its letter, huh? But the meat of the matter is your money, your 50% salary, which I think they are legitimately entitled to. May not be 50%, whatever it is,
Your
but
Lordship, with your permission.
but you can't neglect them.
Your Lordship, absolutely true, absolutely true. Lordship. With your permission, Lordship, now, maintenance audit is there only. We are ready to comply with that. One thing which cannot be ignored by all, even by the court, even by us, is the parties are in the process of mediating their personal disputes. Lordship. So instead of,
You apprise this before the
yes, Your Lordship.
court below, but you appears to be evading.
Yes, Your Lordship. No, we have not, I'm not evading, absolutely not. I have not been afforded with the opportunity to place my defenses, no notice has been issued, straight away this.
Lordship, as per instructions, several summons and notices were issued, Lordship.
Record.
It's there, Lordship.
Record will say.
Record will speak, Lordship.
Record will speak, record definitely, absolutely, I agree to that, record will speak. I have never received it.
There are two impugn orders at page 68 and 69, is not it? 68 and 69,
Yes, Lordship.
annexure 8 and 9, correct?
Yes, Lord. Yes, yes.
As Mr. P.W. Manta, counsel for the petitioner. assisted by Mr. H.
H Tungkang.
H. Sungkang, as well as Mr.
G. Ingan.
G.
G. Ingan.
Ingham learned counsels for the petitioner. And Mr. and Miss L. Hager, learned APP for respondent number 1. Also had Mr. J. Jini,
While be entering my paper.
learned counsel, who and Teju in IA number 13/2018 in maintenance case number 07/2017 at page 68, Srimati Jujumai Toang versus Sri Kanonso Minin. However, NBWA, non-valuable warrant of arrest against the petitioner has been issued, fixing the case. Fixing the case to be listed on 13/10/2023. So also put to challenge is the order dated 29/2023 passed in maintenance case number 7/2017. Srimati Jujumai Tawang versus Sri Kanonso Minin, page 69. By this order, who has been asked to appear? Next order.
Final order.
Okay, just whereby the maintenance case, approximately has been fixed on 13/10/2023 for report and necessary order. So though order dated 29/2023 passed in IA number 13/2018 in maintenance case number 07/2017, issuing NBWA against the petitioner for production on 13/10/2023 has been challenged by the petitioner contending that the same is not in accordance with law. Yet, learned counsel for the petitioner submits that that petitioner is ready to appear on 13/10/2023 to contest the maintenance case number 7/2017 filed by the respondent number 2. So, learned APP, learned Ms. L. Hagen, learned APP, as well as Mr. J. Jini, learned counsel for the respondent number 2, have submitted that if the petitioner is ready to appear on 13/10/2023 before the Chief Judicial Magistrate Teju, in maintenance case number 07/2017 as directed by the order dated 29/2023. This petition may be disposed of, directing the petitioner to appear on 13/10/2023 before the Chief Judicial Magistrate Teju, whereafter the Chief Judicial Magistrate Teju may pass an appropriate order in the maintenance case in accordance with law. Having heard the learned counsels for the parties and taking into consideration of the submission made by Mr. C.W. Manta, learned counsel for the petitioner, that the petitioner shall appear on 13/10/2023 before the Chief Judicial Magistrate Teju in connection with the maintenance case number 07/2017 without fail. This petition filed under section 482 is hereby disposed of, directing the petitioner to appear before the Chief Judicial Magistrate Teju in connection with maintenance case number 07/2017 on 13/10/2023 without fail, on which day the Chief Judicial Magistrate may pass necessary order in the maintenance case number so and so in accordance with law. So, since the petitioner has undertaken to appear before the Chief Judicial Magistrate Teju on 13/10/2023 at 10 hours in connection with the maintenance case number so and so, the NBWA issued against the petitioner pursuant to order dated 29/2023 passed in IN number 13/2028 in maintenance case number 07/2017 shall not be given effect to till 13/10/2023. So, if the petitioner. With that, we'll dispose of.
Yeah.
Okay. In the event, the petitioner fails to appear on 13/10/2023, it shall be open for the Chief Judicial Magistrate to proceed again against the petitioner in accordance with law. With the above observation, this application filed under section 482 by the petitioner is not referred. Okay.
Yes. There is not.
Obliged.
Not a thing that one salary has to be stopped. And salary is-
They will decide on that.
That will, you make some on that day. He will modify. He must, the court must have passed this order. Since you are not paying to her, so let you also not do it. This is not going, I think this will be modified. This will not gain the parties.
Obliged, Lordship.
Yeah.
Yes. Ma'am, please, Lord. Madam, this is a bail application, madam. Your Lordship is already aware of the matter, madam, where there was allegation that 28 teachers in the Longding district, madam, the illegal appointments were made. So this is in regard to that, madam. Here, madam, the present accused person, madam, he is substantially a teacher, madam.
He's a teacher.
Yes, madam. Not an alleged illegal appointee, madam. He is already a regular teacher. So what happened, madam? He was brought to the Deputy Director of School Education, Longding, to assist the Deputy Director in the account section. Madam. So accordingly, he was discharging the account part and also some other matters which were interested him, like, madam, maintaining service books of the employees and all that.
You had approached this court earlier?
No,
No.
no.
Okay.
So I approached the lower court, but bails were rejected. So basically what I'm submitting in this case is here, madam, particularly in this instant bail application. The Deputy Director School Education, madam, under whom I was working, has already been released on bail, madam, by the court below. And the Director of School Education, who allegedly made all those appointments, madam, he was also released on bail by this honorable court, but though on the ground of that sickness, medical and all that. What I'm submitting is, madam, the police is opposing only on the ground that if I am released on bail, I must tamper with the documents which is within the premises of Deputy Director of School Education. Madam. That is the only ground for opposing my bail. There's no other ground. The Deputy Director of School Education, Longding, he was granted bail on the premise that, madam, he is cooperating with the investigation. Whereas, madam, I'm in the custody for almost 2 months. Madam. I was arrested on 2nd August 2023. Madam.
What is the FIR?
Madam, see, the FIR is page 15, madam. This starts from page 15. It is based on an inquiry by a committee. Lordship will find that it starts from page 17.
What is the allegation against you?
The allegation is madam, page 16.
16.
Yes, madam.
Yes.
This number 1, Tapigao, madam. Director, Elementary Education, Government Itanagar during 2000.
You are not Tapigao.
No.
Yes.
I'm a teacher who has been entrusted with the account in the Office of Deputy Director School Education, Longding, madam.
You have been named here.
No,
You
I'm
have-
not in here.
You have
No.
not been named in FIR.
No.
Okay.
So here the number 1 is the director who allegedly made appointment of arrest 2 to 29.
Let us call for the case diary.
Yes, sorry, the call for its one last time it was already heard.
The cities here, ma'am.
CD was called for.
Yes.
Yes.
When? By which order?
No specific order as such, I suppose, Madam, but what happened?
No, how can you produce CD?
No, in other matter, there was similar matter listed. In that CD was called for. In that case, that has been now, my brother has agented matter to 13 or 11th. Or 11th or to 13, it has been adjourned. 11. It has been adjourned to 11. Then this honorable court said, let the matter be listed together. CD is already there.
But there is no any such report.
No, although I admit, it was not reflected in the order.
Okay.
So my submission, one more here is, the investigation of
Just a moment.
Yes.
When were you arrested?
on 2nd August 2023,
2023.
Yes.
Yes, who has taken his name?
My lord,
Who has taken his name?
my lord, we kindly peruse the CD, my lord. Everything is in the CD, my lord. I'll just go to the pages, my lord.
No, there are material against him.
Yes, my lord.
Then
Yeah, damn it,
what-
yes.
No,
Somebody has taken a name, so you have been arrested.
no, I'm not, it's not the case that I am involved in appointing those employees illegally, The only allegation is that, the deputy director of school education, because I am handling the account section, I cannot do anything on my own accord. Whatever is being done in the office of director of school education in the district, that is, as I said, I'm not a regular account officer.
Okay, let us see what you have done. Page number.
One more thing before that, what's happening here, in the lower court also, instead of submitting case diary, the investigation officer has been submitting his own status report, which is beyond the scope of that case diary. And it's trying to influence on the saying, in case of deputy director education, they said he's cooperating only on that ground bail has been given. Lordship will see the bail that has been granted to the director of school education, deputy director, by the court below.
What below?
Yes, madam.
Page number?
We'll find at page 29.
29. Yes.
This is the Mr. D. Lona.
Yes.
It will start from say para 9.
Or not below?
That's why.
Yes.
After hearing all the learned counsel, this court perused the CD wherein the eye of the case is submitted that after his arrest and during his interrogation, accused has stated all his true and valid versions of his role and has been cooperating with the investigation. And the accused has volunteered to record his confessional statement under 164 CRPC and has also volunteered to be approver of case as prosecution. Therefore, the investigation has raised no objection if the accused is granted bail.
Okay, he has done approval.
Yes. Malad, in that case, I will also be approver, Malad, if they allow. Malad, that is not the ground for Malad, that he will be granted, because the police has not raised any objection in regard to Malad, that officer under whom I am working. When that's why I'm submitting Malad on the parity, Malad, when he is on the main, the boss has been already been released on bail, Malad. Why should I be treated differently?
7/9. He was released on 7/9.
Yes, Malad.
Then your application was rejected on 25/9.
Yes.
Did you say that you will also become an approver?
No, we have been already been convinced the investigation. We want to be Malad.
Why your bail has been rejected?
On the same ground, my brother is submitting. Yes, there is material. Malad. That is,
Read. Which paragraph?
Malad, my lord will find that page 27. I'll just
27?
yes.
It can't be 27. You are Amo Wangsu.
Amo Bangsu is the applicant, wife of the accused person.
Okay. Jasi Wangsu.
Yes, Jasi Bangsu.
Your bail application was rejected on
Well, here first 18/8/2023, my lord. And thereafter, on 25/9, 25/9, your lordship will, now objection is, starts from page 35,
yes,
para 14.
yes,
The objection, objecting on the submission made by the DPC learned, SPP, Ms. such and such stated in subsequent appeal applicant has been placed no new grounds. The grounds of granting bail to the accused, DDSC Jomdo Lona and Director Tafiq are different. The DDS was granted bail because he agreed to be approver and has given his voluntary statement before the magistrate under 164 CRPC, and the Director Tafiq was granted bail by the Honorable Guwahati Itanagar bench on health ground as he underwent heart surgery recently at Guwahati. The learned SPP further submitted eye of the case has to analyze the seized documents and further investigate the pending, hence humbly prayed to reject the bill application. After hearing both the learned counsel, this court perused the CD where the eye of the case has revealed that accused was assigned in the account related matters office of DDS office Longding, and he played an important role in opening secret accounts for a DDSC at SBI Longding for illegal activities. He deducted salary of illegal appointee PRTs Longding in connivance with the former DDSC Longding, Sri Jomdo Lona. This illegal deposition amount tune of lakhs of rupees and has been withdrawn by Jasti Vangshu and divided between themselves and other members. He is the one who played active role in opening service sheets of almost all the illegal PRTs appointee. He has been found to have prepared a service sheet on Takaruri, Aken Pangan, Taba Baby and others at Hotel Insura Dibrugarh. Since he plays major in regards to maintenance service record of illegal PRTs of DDS office Longding, that he is responsible for account related matters of the same office. Thereby the IO appears that there is highly possibility that accused may remove the important documents of DD office amounting tempering and hampering of the investigation. This is the one on
yes,
this.
your role is, you was the one who had opened bank accounts
Yes, Mana.
and service sheets of illegal appointees.
No, little correction, Mana.
Hmm.
This is in support of the DDSC Longding. Because I'm working under DDS, I cannot open on my own, manner unless my boss orders me. Here clearly mentioned with DDSC. The DDSC has been granted the bail, man. And maintaining of service books, man. I am a clerical person, man. I have to deal with everything in the district. When appointment comes, man, I definitely have to maintain the service book.
Let us see his statement.
Yeah. Page number 163.
163. $163. What was the name of DDSC?
Jumdo Lona.
Jomdo Lona, who has been granted bail.
Yes, my lord.
Approval.
My lord.
Now this approver,
My lord.
he as an approver has disclosed how many names?
My lord, the 164 statement.
Yes,
It is here, my lord.
page number
164, my lord, 166, my lord.
166.
The relevant part would be 168, my lord.
Hmm?
168 page, my lord, the relevant portion.
168.
8.
Yes. No, he has disclosed how many names?
My lord, in fact, my lord,
Just a moment. Altogether, how many, as this is based on inquiry report, is not it?
yes, my lord.
How many persons have been named in the inquiry?
Earlier, my lord, there were 28 illegal appointees, my lord. 28.
Oh, these are the illegal appointees.
Yes, my lord, the 28 illegal appointees, my lord. But during the course of investigation, my lord, it has been found. Now it is the number has increased to 38, my lord.
All right. Here the number of accused is not mentioned.
No, no, my lord. No.
All right.
They are only the initial illegal appointees which were found. Those are mentioned.
How many arrests have been made?
Only 2 as of now, my lord.
Well,
2.
only two.
Yes, my lord.
Two have been arrested.
Yes, my lord. The incumbent DDSC and
One-
the present petitioner,
One is this person
my lord.
and another.
The incumbent DDSC. Lona, Jumdo Lona.
Okay, who has been?
Yeah, my lord.
Altogether, how many accused are there?
As of now, like, it is just during the course of investigation, my lord. But apart from the 38, my lord, there are certain officers, my lord, including these 2, 38, 14. Then another one, Pinka and Tiwari.
No.
Yes, my lord. Around 45, my lord.
During the course of investigation,
New, facts are coming. So new facts are coming out, my lord.
as of today,
My lord.
you have how many names as a suspected accused?
Uh,
During the course of
I don't have the exact
investigation,
number, but then it would be around 45.
it will be there in the.
Yes,
diary.
but then they are not been named as my lord, accused, my lord. Their statement have been taken in, my lord. They are just suspects as of now, my lord. Suspected to be involved, my lord.
45.
Approx, my lord. Yeah.
And what has revealed this person, approver?
My lord.
This approver has revealed, what has he revealed as an approver? He is now a special person.
My lord.
Now he will tell you the entire person involved.
Yes, he has revealed.
He has
so
taken
many
whose
names.
name? How many names he has taken as an approver?
As an approval, as of now, the director, one Mr. Pinka and Mr. Tiwari. Tiwari.
Only 2.
As of now,
They are known from before, even before he became the approver.
no, my lord. My lord, in fact, the illegal appointments, my lord,
Not the illegal appointments. Accused, suspected accused
my lord,
during the course of investigation.
as of now, 3.
Only 3.
3.
Then we will release him. You know that? Just and who are those other 2 who have taken dates for 13?
My lord,
13th October?
that's already there in the bail application also. There are names are reflected by Mr. Pinka and one Tiwari.
It was listed today.
No.
No, my lord.
Oh, yes, one Mr. Tapa Pinkas was listed today, man. It has been postponed to 11th. Yesterday. It was listed yesterday and today also. But it has been.
Item number?
Oh, yesterday it was listed, man.
It has been posted for 13th.
11th.
11th. my lord.
11th.
Pre-arrest bail.
That is
a pre-arrest bill.
pre-arrest bail. And what is these 2, I don't know, 5 and 6 of today? This is other matter. Okay. Now you are saying that two other bail applications.
No, my lord, yes, I just forgot. It was yesterday, it was Mr. Pinkas was listed. So only apprehension was, my lord, that they shown was that I might tamper with the documents of the DDSC office. My lord.
No, Mr. Tapo,
No, in the
see,
court below.
you are definitely involved. But the manner they are progressing the investigation, you may be entitled to be released on a bail. Is 164. And what is the statutory period for completion of investigation? 60 days, 90 days.
Yeah, 90 days.
But what about this Tiwari?
Tiwari, my lord, as per my instruction, my lord, they appeared and they have given the statement, my lord, but then they were not been arrested, my lord. Tiwari and Mr. Pinkala.
Okay.
Uh,
It is there in the case diary?
Yes, my lord, their statement is not here, my lord.
Oh. Lona was arrested when?
Seven.
27/7/2022.
And he was granted bail
On 7/9/23. One more clarification, Mr. Lona has not been made in his approval. They want to make in as approval.
Yes, anything else?
My lord, mechanic page number 20, my lord, that's the,
20.
yes, my lord. The relevant part of the, my lord, para 7, my lord. No, my lord, 200,
200.
200, my lord. Last second, last second page.
Yes. Yes,
Para 7, my lord.
this is the comments.
Yes, my lord.
Okay, yes, para 7, yes.
Eight also, my lord. This is how the illegal appointments were made and the service will be prepared, my lord.
Services of this illegal appointees have been terminated.
Yes, my lord, 20th members, they've terminated, my lord.
Have they filed writ petition?
So I think some of them has approached this noble court, my lord.
Saying that without notice.
That I don't know, my lord. I'm not aware of it. My lord.
And there will be stay without notice, no? By the writ court. And they continue to.
I think Mr. Tara was appearing for them, I guess so.
Okay. He is not here today.
He's not here today.
Okay. Otherwise, he would have jumped in. Yeah. Anything else?
No, my lord. As my lord is very aware, my lord, it's a PCA case, my lord. So the seriousness and the nature of the case, my lord, and as to how it has to be dealt with, my lord is very aware of it, my lord.
Chidambaram.
My lord.
But you have let Tiwari go.
No, my lord, my lord.
Huh?
As of now, not my lord.
No. You have said he came and
Yes,
his statement was recorded.
His statement is recorded, my lord. Mr. Pingas is the I can leave it to my.
How many such bail applications are pending?
Uh,
In connection with this?
Another one, Mr. Pinkas only.
Only one, my
That
lord.
is AV.
AV.
my lord.
I'm the only one who was arrested one more.
Lona and you were arrested.
Yes, ma'am.
Only these two persons were arrested.
Yes.
My lord.
All the top guns, they're going soft on top guns, my lord. Small pride like us has been made as a scapegoat. Otherwise, my lord,
But you are also not disclosing much. You disclose more.
no, my lord, just after 5 days, my lord, of my being arrested, I was put into judicial custody saying that I have divulged everything. Thereafter, they have not sought for police custody at any point of time in these 2 months. I divulged everything, man.
This is your first bail application before the
Here,
court.
yes, ma'am.
Yes, ma'am.
Well, therefore, I'm not a person that will abscond, madam. And the DDC office is not under my custody to manipulate anything with regard to documents. And I'm local boy. There's no chance of absconding. I'm when the deputy director of school education, who is my boss, has already been released on bail, madam. At parity, my case may also be considered. That's all I'm praying.
No, school. Why you did not oppose the bail of Lona?
My lord, as per me,
He consented to be an approver.
he consented to give the 160, voluntarily give the 161 statement. Oh, sorry, 164 statement.
He will also give.
My lord, the opportunity was given to him, but then.
That's when I can keep my
No,
statement.
no,
down,
see,
madam.
contention of the PP you see at paragraph 8 at page 31. Learned special PP has submitted that as the accused has consented to be an
Yes.
approver in the case and has been cooperating with the investigation,
My lord,
the IO has raised no objection on granting bail to the accused person. Hence, he also does not have objection on releasing him.
No.
He is also ready to be an approver.
therefore, my,
Actually, he is also cooperating.
therefore, my lord, voluntarily he wanted to give the 164 statement, my lord, but at the right moment when he was sent to the judicial magistrate, he declined
Who?
the present petitioner. my
That
lord.
can be, to be approver, madam, I need not give 164.
All
After
right.
Whatsoever, my lord, that was
Just a moment. This order was passed on 7/9/2023.
my lord.
Then as an approver, his statement was recorded.
No.
No, my lord.
You get that instruction by 2. Because once he become approver,
My lord.
he will discover lot many names. Isn't it?
But then, my lord, 164 statement is like, my lord. it is-
164 is he has taken the name of director only.
No, my lord, he has name.
How many persons?
My lord, can you come to that
Let
statement?
us say. How many persons?
Yeah, no,
164.
160, page number 166, my lord.
66. And relevant party 68.
Yes, my lord. '69, my lord, the second para, my lord.
Okay. 1, 2, 3, and 4. This fourth one too you have let off.
Only,
Fourth one you have let off. Though he appears to be the main accused, one of the main accused. He came, you did not arrest. Only 4 person he has disclosed.
no, my lord, there are so many names down below also, the Israel, my lord, the minister, the present minister also. And the district GV president of Longding district.
Where?
They also will name, my lord.
Paragraph. Page 169. Second paragraph, we can see 4 names.
Yes, my lord.
And then
I-
apart from that,
just- I-
okay. Where are other
Down,
names?
down below, my lord.
Down below.
Yes, my lord.
Which paragraph?
The same paragraph, my lord, the last,
Okay.
last second, last chart.
All the. okay.
Therefore, they appointed. My lord is worried, my lord.
Yes.
Yes.
All right, we'll continue at 2.
May it please, your lordship.
Yes.
Your lordship, I deeply apologize, but due to some health condition, I'm not being able to stay longer in the court premise, your lordship.
Ah,
If your lordship may kindly adjourn item number 12,
Yes.
13,
ah,
and item number 2, your lordship.
2, 12, 13.
Yes, lordship.
Who is for the other side?
2. Mr. Soki was here. I had already informed him.
You have informed, okay.
Yes.
12, 12, 13 also?
12.
13, 12 for.
You are there. Fine. When do you want?
12.
Tomorrow, I can hear.
Tomorrow? Huh? 9. Okay. So 12 will fix on 9th?
Yes.
Okay, I think 12 on 9th. And 2.
Item 2. Use the-
What about 2? Soki one.
On tenth, your lordship.
Okay, on 10th.
And with regard
13?
13, your lordship, the service upon respondent number 2 is still awaited, therefore after vacation.
Okay, 13 after vacation. All right,
Deep level.
yes. Yes.
Yes, Mother, I have submitted whatever is there, Mother. Just
Hmm.
on the parity, Mother, I'm harping on the ground of parity.
Hmm.
Yes, I have been cooperating and I've already recorded my statement, Mother. In the first 2 days, itself. Otherwise, other accused persons, alleged accused person, they also recorded a statement. My brothers has already indicated, they were not arrested. And one more, Mr. Murli Dharan, who was my head assistant, below whom I worked. He was also not arrested.
Dharan.
No, Murli Dharan, head assistant of the deputy director, school education office,
You
under
are-
whom I work.
You are accountant.
Yes, accountant charge, I'm not permanent accountant. I'm a teacher.
TGT teacher,
Yes,
accountant. Accountant in charge.
yes. To look, not exact, to look after the account section, that's all.
Okay. And Ms. Jondal Lona is DDSC.
Yes.
At page 161. Come to page 161. When was this statement recorded?
26, my lord.
26th of November, so September.
Yes, my lord.
Whose anticipatory bail is pending?
My lord. Fixed on 11th.
We have recorded his statement also.
But then, my lord, we will be objecting his bail application.
Huh?
We will be objecting his bail application, my lord.
It's very curious. Huh?
Yeah, that's I don't want to say more, Malad. This is a very peculiar case, Malad.
Hmm.
All the big fish, Malad. No, none is being arrested.
Hmm.
That's for the instruction which my lord is sought for, my lord.
Which instruction?
You ask the IO whether that statement has been taken or not in respect of the DDSC. We have we have sent in a prayer for making an approval to the special judge, my lord, on 20th September, my lord. And he has been called for, my lord, for recording the statement on 6th, my lord, day after tomorrow, my lord.
When was Tiwari's statement recorded?
Same day, my lord, on 26.
26.
26, my lord.
26.
My lord, as per the instruction, my lord, I've just had a telephonic conversation with the IO, my lord.
Oh.
They've informed me that, in fact, as of now, we don't have concrete evidence against these two persons, my lord. As of now, we have only the statement, verbal statement of the co-accused persons, my lord. And then we are,
How do you say that this was recorded on 26?
my lord, because the summons were issued on 26, my lord. To appear, my lord. That's why, my lord, when the case was fixed, my lord,
But there is no date recorded in the statement of recorded under 161.
yes, my lord.
There has to be a date, I
Yeah.
think, on which it was recorded.
Yes, my lord. My lord, in fact, when the case was fixed, my lord, the matter was not taken up, my lord. That's why it was fixed on 28, my lord.
Which matter?
This Tapapinke's case, my lord, the
Ah.
AB, my lord, application. So at that point of time, I was informed that on 26, they were called for to give their statement. The summons were issued, my lord.
But whenever you actually record a statement under 161,
My lord.
should there not be a date?
Yes, my lord, there is.
Where is that date?
Sorry, Manoj, I have never seen the investigation officer or IO recording the date in any of the case.
Okay. Then how,
My lord may come to page
Any-
158, my lord.
how anybody will come to know that when this statement was recorded, if it is
No, my lord,
relevant?
it is in the CD, my lord. Now, my lord, the portion which I'm showing is the statements, my lord.
Ah, page number? Page number?
158, my lord.
Yes. Yes,
In the second paragraph, my lord.
section.
Once the Tapapinka, the prime accused individual. My lord will find the date in the first column, my lord.
Okay, yes, yes. Hmm.
10.
Then, is it?
I have some difficulty. I will not be available next week. So let it
Oh.
after vacation. I will be out.
All right, you info, no, you are not the people.
No, my lord, here I am the respondent number 2, my lord.
Respond
Oh.
back
Okay, you inform then,
to-
PP.
It will be after, let it be after vacation.
Oh, after
All right.
that. Item 2, no?
All right.
Yeah, respondents are appearing for the first time, my lord. The cause list also, my lord, their name has not appeared, my lord.
This is item number 9.
We will file the Wakalatnama matter. And kindly peruse the last order passed by this honorable court matter. Wherever there is a entry order granted by this honorable court matter. May I read the order dated 13/7/2023 matter?
Yes.
Second paragraph onward. This civil revision petition is directed against the order dated 4/7/2023. It's in my execution proceeding matter. Passed by the additional deputy commissioner COME Mechuka Abide, such and such, by which the Keba decision dated 29/10/2001 is sought to be executed. Mr. Solicitor's Counsel for the petition submits that the aforesaid Keba decision dated 29/10/2021 was challenged by the petitioners herein by filing an appeal being civil appeal number such and such before the district judge West Siang district Alo, whereby the learned district judge West Siang Alo upheld the Keba decision dated 29/10/2021 in the judgment and order dated 27/9/2022 passed in civil appeal 1 of 2022. The aforesaid judgment and order dated 27/9/2022 passed in civil appeal number 1 of 22, whereby the Keba decision dated 29/10/2021 has been appealed, has been assailed by the petitioner in a regular second appeal matter in RSA number 5 of 2022 before this honorable court, which the appeal has been heard by the court on 29/5/2023 and the judgment has been kept reserved. Next paragraph, my lord. Last paragraph. Since the decision rendered by the learned district judge West Siang Alo in civil appeal number such and such, whereby Keba decision dated such and such has been upheld, is under challenge in RSA number such and such 5 of 2022, which has already been heard by this court and judgment has been kept reserved as stated above till the returnable date. The impugned order dated 4/7/2023 passed by the additional deputy commissioner COME Mechuka Vice such and such shall remain state matter. My lord, on my lord, 26/9/2023, my lord.
Just a moment. Oh, no, was it father? Yes, sir.
My lord, this RSA, which was my judgment was reserved, my lord. On 26/9/2023, my lord, it was disposed in principal seat, my lord, dismissing the, my lord, the IA which was filed for, my lord, stay of the execution proceeding, and the RSA was dismissed, my lord.
My lord. May I, my lord?
No, just a minute.
I mean, basically,
Okay, As the
basically,
thing
my lord, is state the, my lord, the
execution procedure,
proceeding only because
because
that, my lord,
the
RSA was, my lord, judgment was under reserve, my lord. That's why, my lord, it was stayed, my lord. And by now, my lord, on 26/9/2023, the same has been, my lord, the RSA was dismissed. In the
okay, it has been
principal
delivered. Okay, judgment delivered.
seat. Judgment delivered by video conference, my lord. It was dismissed, my lord, but yet to get the copy of the hard copy of the marriage judgment, my lord.
Okay.
This is the, my lord, stage that the.
Then what are you challenging here?
The
He is challenging the
execution proceeding.
Execution proceeding, my lord.
Execution proceeding.
Yes.
Then this has to go.
Yes, my lord,
Huh?
I am challenging the execution proceeding, my lord.
Execution proceeding, or not? Mr. Pada, you take back the case there after I sign the order. All right, yes, we keep it here. And,
I can take it tomorrow.
Tomorrow, okay, all right. You, case diary, have you taken back?
Yes, my lord.
Okay, you keep it here. After I sign the order, either you can take it this evening or maybe tomorrow.
Well, I am challenging the execution procedure. If they have any problem, they can file their objection. This is with
No,
regard to
but-
execution procedure. The consideration may be taken by your lordship in another aspect also, but my proceeding, what I am challenging is the execution procedure. If they have any objection, they can file their affidavit.
Execution.
I'm not against the second appeal. Order passed by second appeal or the first appeal.
On what ground do you challenge the execution proceeding?
Today I was on the apprehension that I have to again serve the notice because in the cause list, they have, their name is not appeared.
No.
So
On what ground you are challenging the?
today, I'm not prepared. Honestly, I'm not prepared because I was on the apprehension that I have to again serve the notice, because I have to again serve notice to the respondent. In the cause list, their name has not shown. I don't know whether they have filed wakalatnama or not. Without wakalatnama, how can they appear, firstly?
Technical matter, objections matter, we filed the wakalatnama also matter.
They can file objection.
My humble submission is that matter, and I with that matter RSA, there was also an application for stay of the execution proceeding matter. That was also dismissed matter. My learned friend has to be very fair before this honorable court matter. My lord, let the matter be taken up on next Wednesday. By the time, my lord, all the judgment will come. We will get the
After
hard.
break, because honestly, if there is any chance for SLP, we will go for SLP also.
That cannot be, my lord.
My lord, the Kemal decision has been passed by this XAS, PI,
Next
I-
week, next week?
Next week,
next week,
Huh?
I have one case, I would be out of station,
Then Monday, my lord.
After break,
We are, my lord, expecting, my lord, the judgment will be, hard copy will be reaching to there, my lord.
He's playing for next week.
Public
So
leader,
there is-
public leader, PI, XAS, they have they have passed the Kemang decision. I don't know, what kind of judgment.
That is subject matter of second appeal.
Yes. Well, that's why, at least I should,
that is what
being a
I-
fair.
In fact, I fairly submit, my lord, even when this present, when the CRP is not maintainable, it's all, my lord.
Let them file objection.
When there, my lord, no, you insist this things.
That
Let
is
it be on Monday, my lord, and
Monday.
instead,
My lord,
this should not be continued, my lord.
I have one SLP, my lord. In
What
the
is
Supreme Court, my lord.
Huh?
One judgment passed by your lordship and division bench has interfered, and then we have moved to SLP, my lord, Supreme Court.
Which one?
Dukin Kato versus Yidak Angum, the state of
Ah.
AP, my lord. Yes.
Okay. No, that is, you sort it out. See, he is saying that next week.
Well, they can
Yes,
file
yes,
objection, my lord. They have to file objection, my lord. Because the maintainability of the case would be lie in my CRP only, my lord. Not the fate of RSA will not decide my CRP, my lord. They have to file objection, my lord.
Then you
To my RSA, my lord.
argue on merit, why you filed the,
Let them, my lord, file
I
their
know.
objection first.
I know, whether,
In that case, that's an admission, my lord.
You give any date next week, Monday to Friday, any date, as per your convenience,
Friday, my lord.
Friday,
My lord.
most inauspicious day. Okay, we'll take it, Friday. 13, I think, huh?
13.
Okay. You, in the meantime, you file wakalat now?
no, we have already filed, my lord.
Okay.
Yes, ma'am.
Mr. B. Pichel, the counsel for the petitioner, and Mr. R. Saike, the counsel for the
Respondents, my lord.
respondents. There are two respondents.
No, my lord.
No.
There are altogether
Five.
five respondents, ma'am.
All respondents.
My lord.
Okay, represent all the respondents who submits that who submits that he has already filed the wakalatnama. Yes. Has agreed to allow the counsel for the parties. List this matter on 13 October by placing on record the wakalatnama file. on the
My submission
respondents.
also will be recorded that, my lord. The RSA was, my lord, dismissed, my lord, on 29, my lord.
No, that will.
Yes, my lord.
pass
They can
order.
produce.
We'll take a note of it.
Interim order may continue.
No, my lord, that may not be, my lord.
Huh?
That may not be minor, because primarily minor was concerned about, because the RSA was, judgment was reserved, that's why minor has simple protection was.
Okay, we'll see on that day.
Yeah, on the day, my lord.
Nothing,
At least till then, my lord,
nothing will happen till that day.
my lord, we don't know, my lord. They are always trying to, my lord, shoot us from back, my lord.
Well, I have
On the RSA
I have
also, they
no-
have assured that
I
no
know.
execution proceeding would be initiated. Now, while the RSA was pending, my lord, they have initiated execution proceeding, my lord.
We'll try to dispose it of on 13.
At least my lord, till 30.
If, no, if not, we'll reconsider your.
Yes, definitely.
They have to file objection, my lord. For
Yes,
modification also, my lord, they have
It
to
is
file.
up to them, they will file, not file.
At least until 13, my lord. Interim order may be considered.
No,
Nothing will fall, my lord.
that cannot be permissible minor.
My lord, the order has not been drawn.
Behind the minor, I have not
See.
open my mouth, minor. In the guise of minor filing this application, this and there's those applications, they are constructing minor.
No, my lord. That would-
We have to prove minor.
Based on 13, 13 will consider,
Minor.
Let them file their affidavit.
because the stay was only on the ground that RSA is CAV.
Yes, my lord.
It has been delivered,
That effort-
dismissed, went against you.
Yes, my lord.
We'll see on 13. Huh?
Until 13.
You have not even told on what ground you are challenging the.
My lord, I am challenging the proceeding, my lord, because
Uh-huh.
in the execution, my lord, there has to be some proceeding, my lord. Straight away, they cannot execute, my lord. They cannot
We'll see
any
on,
decision,
on that day,
my lord.
because some new developments, vital developments have taken place.
My lord.
RSA,
My lord, again, they will take advantage. of-
now they are the degree holder.
my lord. The assurance, my lord, the execution would be not proceeded, my lord. Their assurance may be recorded, my lord.
No.
Because
On-
they will press the matter again.
No assurance, either there will be an injunction from here or no injunction, no via media. No, all right,
Well,
13, come back on 13. Yes.
Hello, sir. Lordship, service against sole respondent is still abated. Lordship.
Huh?
Service against respondent is still abated. Lordship.
Okay,
My lord, here, my lord, we are appearing for the sole respondent, my lord.
I don't know, 10,
Yes, madam, and we find a vocalat number also. my lord.
okay, all right. You, for all the respondents,
My lord, a sole respondent.
okay. And what is to be done today?
We will file objection to
Okay.
the, my lord.
Or Mr.
K. Lone, Lordship.
K. Lawler, counsel for the petitioner. And Mr. R. Sekya, learned counsel for the sole respondent, who submits that he has filed wakalat nama on behalf of the respondent, or on behalf of the sole respondent. In view of the error, and is grateful with the learned counsel for the parties. This it will be after vacation? Yes,
In the, my lord, in paragraph 22, they have made a specific environment, you also find at page 14, my lord. At page 14, my lord, last line, my lord, hence, my lord. Hence,
Yes.
this instance civil revision petition, revision along with the condemnation application for delay under section 5 of the Revision Act, my lord. This is being accompanied with a, my lord, section 5 revision, we have not received that copy, my lord. This is because, my lord, the Kellen mail is, my lord, of
Have-
2017, my lord.
Have you filed a delay application? Sorry, the delay condemnation application? Then what order passed on last occasion, yeah? 9/8.
Last-
We'll see on next day.
My lord.
After vacation, we're placing on record the wakalat number filed on behalf of the respondent, also respondent.
Lordship, may I please?
Ah.
Lordship, this is criminal revision petition.
Ah.
And beside one IA for condemnation of delay,
Okay,
6 months and 10 days of
6
delay.
months and 10 days.
Yes. And the ground of delay, the petitioner is a regular student of Himalaya University, law BLLB student of Himalaya University. So there was some financial constraint and also a regular student, being a regular student.
You are challenging what in the
Uh,
criminal petition?
Yeah, my lord, this is challenging the order, rejection order passed by the GMFC UPR, the cognizable offense. 417 of IPC, allegation was 417 of IPC, that is punishable 1 year and or fine,
What is 417?
cheating.
Cheating. 417 is cheating.
Yes.
Hmm.
For only 1 year's punishment is 1 year or fine.
Hmm.
And in that regard, the informant and the accused person jointly file application under section 320 of CRPC, praying for compounding the offense. The
Okay.
offense was compoundable in nature.
Ah.
So, however, the learned CGM UPR did not accept our prayer and rejected the application. That's why this criminal revision application filed for the Honorable Court.
So the case is at what stage? Trial is
PW1, complainant PW1. CC framed under
yes.
section 417. Notice was issued to the complainant.
You want to file objection?
Lordship, here, Lordship, today IA may be disposed because, Lordship, for the main petition, Lordship, record may be called for because as per
No,
the
no.
court,
What about the IA?
IA is for condonation, Lordship.
You want to file? You want to file objection?
Lordship, Lordship, here, Lordship, they are concerned that, Lordship, that accused was a law student. He was pursuing his degree, so they could not approach the court. That was their condition.
Only July, only 21 June only their semester examination was concluded. And this application was filed on July. So there was financial constraint right there and also regular present in the class and preparation of the exam. That's why delay was there.
Himalaya University is here. Or?
800.
Examination of court here. Okay. Mr. Who is accused number 2? Sorry, petitioner number 2.
This is complainant.
Complainant.
Advocate Navam Rama.
And what about petitioner number 3?
Petitioner number 3 is co-accused.
No, 3 is complainant.
Yes, yes.
3
1
is
and 2 is the accused person.
1 and 2
3
are
is
the
the
complainant.
advocate who was the informant of the main case.
1 and 2 are accused person.
Lordship.
Okay. Mr. T. Torum, learned counsel for the petitioners, and Ms. L. Hage, learned additional public prosecutor for the state representing the sole respondent. This is an application under section 5 of the Limitation Act 1963, paying for condoning the delay of 6 months and 12 days in filing the criminal revision petition number 23 AP of 2023, which revision is directed against the order dated 20/10/2022, passed by the London Chief Judicial Magistrate UPA in GR case number 401/2015 under section 417 IPC. However, the application filed by the petitioners for compounding the offense under section 417 IPC has been rejected by the London Chief Judicial Magistrate UPA. So, the petitioner the petitioner number 1 and 2 are still to be the accused in the opposite GR case, and the petitioner number 3 is stated to be the complainant. So, seeking continuation of delay of 6 months and 12 days in filing the criminal revision number so and so, the applicants state that the petitioner number 1, who is the main accused in the case in the opposite GR case, he is still a student.
Yes.
He is a regular student of law at Himalaya University, Itanagar. So, as the petitioner number one was pursuing his regular LLB course at the Himalaya University, the petitioners could not approach this court. The petitioners could not file the opposite criminal revision petition number 23 AP of 2023 within the stipulated time. That is the only ground.
Yes.
Uh-huh.
Only June 21 only the
Within
semester examination was culminated.
Within the stipulated time, challenging the order dated 20/10/2022 passed by the London CGM UPA in GR case number so and so. Okay, under section so and so. Yeah. On consideration of the grounds assigned by the applicants as highlighted here and above, I am of the view that the petitioners were prevented by a sufficient cause in not preferring the criminal revision petition number 23 AP of 2023 within the stipulated time. So accordingly, the delay of 6 months, 12 days in preferring the preparing the criminal revision petition number 23 of 2023 is hereby condoned in the interest of justice. I stand alone and disposed of. In view of the hard Mr. So and so. In the revision petition, in view of the order passed today in IN number so and so. Let this revision petition after vacation.
Any convenient date. So
Okay, this is taken up for consideration. So had Mr. T. Tolu and counsel for the petitioners and Ms. L. Hage, APP for the solar. You should notice. Returnable in 4 weeks. Call for the scanned copy of the GR case number so and so.
my lord, till returnable date, the proceeding of the trial court. may be
No, but
suspended.
it is not going to. And anytime soon. Before that we will decide.
This after lawsuit.
This after 4 weeks.
Okay.
Yes,
Not sure, take it step on this one.
you have taken a step. Had Mr.
Chika.
G. Gatul counsel for the applicant who submits that the service report in respect to the sole respondent is awaited as indicated in the office note dated 29/9/2023. In view of the error, list check after 4 weeks with service report of the sole respondent. Okay. Twenty.
We please, your lordship.
Condonation application.
Yes.
Mr. You declare counsel for the applicant. Issue notice. Returnable in 4 weeks. Steps for service of notice upon the sole respondent.
Yes,
Be
only.
taken by registered post with any AGLS by usual process within a week.
Highly
Listed up to 4 weeks. Okay.